Okay, hello everybody. Welcome to What's the Legal. Today I have a very special guest. His name is Raees Mohamed. He is the founder of RM Warner Law and very skilled in the world of internet law. He helps represent clients in a number of complex litigation matters, and one of them is defamation law. So Raees, welcome.
Hey, thanks for having me, Andrew.
Thank you. So, defamation law, how would you describe it?
Well, it's a good question. I mean, defamation is in the eye of the beholder, right? Sometimes, but the way a court would define it, or the way our states define it, is really quite simply a few elements, right? It's a false statement that is published to a third party, and it's about a distinct person. So the statement identifies, a person, or we can conclude or induce who that person is from the statement. And the statement is not otherwise privileged. It's not protected by truth or the First Amendment. And it results in some sort of harm to the person that it's being published about. And the harm, depending on what state you're in and what the statements are, sometimes we can presume harm from certain kinds of statements, right? So if the false statement is accusing you of having a venereal disease, or accusing a woman of being unchaste, which is, believe it or not, still on the books in most jurisdictions, right? And or if it's accusing them of being incompetent in their profession, or of a crime. Those four typically in most states that have a per se qualifies defamation per se, and damages are kind of assumed, although you still should probably prove damages if you want something.
Sure. Well, I'll tell you, 2020 has really opened up the eyes of media and the legal landscape with defamation law. Would you agree with that?
There's been a lot of things going on in the United States and internationally about that just leans on defamation and privileges and First Amendment, and it's been a real interesting year for sure.
So, in your experience with your firm and the work that you do, what do you see as one of the bigger challenges when representing clients in defamation matters, or even advising individuals on what they should or should not be doing?
So great question. Probably still one of the most significant issues with somebody that has a great case. When I say a great case, I mean great iterations or postings of defamation about them, is we can't connect damages very well. And that continues to be a problem in any case, right? So if you're suing for damages, then you better be able to prove causation, that whatever this person said or posted about me on Instagram or in a video that got circulated is causing me harm. And, causing harm is something for judges nowadays, it's hard to digest, believe it or not, because in 2020, everybody's used to online banter.
Oh,
Right.
everybody's being insulted, offended, humiliated. Everybody's a victim right now.
And so it's not enough to say, well, you hurt my feelings. And with that in mind, there is something as emotional distress. There is something as creating panic in somebody, and creating emotional distress and mental anguish. Hard to prove unless it results in something. I had a call just the other day from a minor who started cutting herself. Like, that's provable, right? That's actual harm that can be
Right.
demonstrated. So that's always a challenge. And the other challenge is, of course, sometimes proving falsity, because remember, as a plaintiff, the burden's on you. You have to show that this is false. So what does that mean? Well, you sometimes have to get into the nitty gritty of your past or your current reputation. And plaintiffs don't always love that.
And one element that seems to trouble many people is the public figure carve out, and somebody who is considered to be in the media, an influencer, a thought leader. Both you and I are definitely out in the public eye. So how does defamation law really make it challenging today for people like us? Because there's this mindset that, well, because we voluntarily place ourselves in the public eye, that we can't be hurt, that these individuals can't be touched. And I don't think that's entirely true. What do you think?
Yeah, I agree with you. First of all, real issue is whether they are a public figure for purposes of what they're being defamed about. Right. And so, and then there's different standards. There are public figures who are essentially celebrities, politicians, and then there's a lower tier called, a limited purpose public figure. So to give you an example, a public figure would absolutely be a celebrity. Anybody who's, famous, renowned, even if not every single person in the world knows them, generally speaking, people are aware of who this person is and what they're doing in their life.
Sure.
Limited purpose public figure could be a doctor that's the president of their association that is getting a lot of press, or who interjects themselves into a hotly debated issue like the COVID vaccine. And if people start calling them out and saying inflammatory or defamatory statements, it could be a slippery slope. It could be a slippery slope. But I tend to agree. I think it's an overplayed alleged defense that, you're a public figure, so I can say whatever I want to you. It doesn't really work that way.
And that gets into the area of this online bullying, online harassment. And, in my work with the anti-bullying activism, I believe I think it's like 47, 48 states that have some form of an electronic harassment law. Correct me if I'm wrong. Most states have them. The problem with the states that do have them is that the penalty for the cyberbullying, the online targeting, direct targeting, the criminal provisions are just slap on the wrist. There's not a lot of real oomph behind it. So getting into defamation, what do you see as one of the biggest fallacies or biggest myths that people think or attribute to defamation or these bullying behavior that's just wrong?
I think the biggest myth is that, you can't really hurt somebody with words, and that this should not be punished or that we should take it lightly. It is very difficult to get law enforcement, as you know, to do something about bullying incidents unless it results in a physical altercation. And at that point, we already have laws to protect people against assault and battery and things like that. What we're really looking for is something to hold somebody accountable for what they say about somebody that's false or harassing them, which is slightly different than defamation, but that is causing real harm, especially when we get into, minors. It's interesting you bring up electronic communications, because you can absolutely harass people with electronic communications. And there is an absolute divide between law enforcement and, criminality and, the civil side. Sure. But I do think that some of these things that you described cross over into the criminal side. Like, for example, texting somebody every single day saying, I'm going to post these pictures about you, or you are this kind of person. I'm going to tell people that you assaulted me, or that you had, you forced sexual intercourse with me, when we know it's provably false, just to get a reaction out of that person. I mean, how is that any different than putting your hands on somebody?
Exactly. And that's kind of the, international law calls it the effects principle, but
that's right.
It's basic, as you know, you don't have to be physically present. And when you are causing enough direct harm into a jurisdiction, a state, anywhere, it's almost as if you were there yourself doing it. So it removes that physical element to it. And, this area is troubling to a lot of people. And, I know we briefly talked about this controversy behind Section 230 of the Communications Decency Act, which for decades has protected media outlets, news networks, and individuals or entities that are considered to be publishers. So let's get into publishers, the element of what a publisher is, because yesterday, as many of us have seen with the congressional hearings where Mark Zuckerberg and Jack Dorsey were called to testify again about their terms of service, their privacy policies, and quite frankly, this horrid 2020 election season, many people, including our legislators, don't understand what it means to be a publisher. Ted Cruz, in my opinion, bastardized what it even means to be a publisher. And I guess to turn it to you, why is it so difficult for people to grasp that concept?
I think it's difficult to grasp because we are so far removed from when the law was first enacted that there's a lot of legal catching up to do. And let's face it, a lot of these old dudes that are sitting in Congress and right have no idea. You remember these first hearings on privacy, the kinds of questions they're asking?
Embarrassing. I remember it was, I forget
Horrible.
who, I think somebody had asked Mark Zuckerberg, well, Mr. Zuckerberg, we understand, how Facebook works, but how does it make money? And it took everything for him not to laugh, and he was just like, well, Senator, advertising, like that's every outlet. So,
right, and they kept kind of accusing him of like creating a device, like, oh well I have Facebook, like I'm like, the people. So that's the problem. You need people who are 20 somethings, 30 somethings, or people that really understand the guts of how this stuff works, industry people sitting in those chairs. And there's not enough of that. There should be people on the panel who are attorneys, people like you and I, who are questioning the big 5 tech companies, and asking these questions about, hey, we understand you have terms of service. The law on terms of service says XYZ. Why don't you act as if they are a contract with you and your user? You don't do squat to enforce your contracts,
right,
if indeed they're contracts. And so there's a massive divide. It's a knowledge divide. It's a practical divide. And you see it in a lot of these areas where, again, you're talking about dinosaurs, and technology. They don't fit well together. And that's a problem. And we need to do, people like you and I fortunately are in this mix, but there's not enough being done to educate people.
I couldn't agree more. And for those who aren't familiar with Section 230 of the Communications Decency Act, can you define it or explain it in the most fundamental way possible? Because even then, people don't understand. Our own senators don't even understand Section 230. So how would you define it for somebody who's never heard of it, never seen it, doesn't understand it?
Yeah, absolutely. So Section 230 of the Communications Decency Act was actually an amendment to existing law to apply to telecommunications companies. And since then has been extrapolated many times over to apply to internet platforms and social media providers. But in a nutshell, the statute was enacted with the intent to say, listen, user-generated content that is published, you're a publisher. If you publish something that you don't create and you don't editorialize, we don't think that you should be held liable for it. And we'll talk about an important exception in a second. But the logic makes sense. It's like, look, I have a playground, okay? And in my playground, people come here and they're welcome to put their own swing set and their own their own campgrounds, their own play area. We don't really regulate that. If we build it, we will. If we control it, we will. We're liable for what we say. But since we're not the speakers of this content, we're not going to be held liable. And the incentive was information flow, right? This is in the early 90s. The incentive was information flow. An interesting thing that if you look back into like the archives of these hearings, the origin of this is actually pornography. No surprise to anybody in the internet world, right? What happened was, if you Googled green tennis shoe, pornographers were able to get you to land on their page. So you could search grandma's old socks. You could search sweatshirt. You get my point. Everything was going there, and it was creating liabilities because now you have minors. Now you have, the record keeping requirements. You have disclosures. It's like, hey, we're not controlling this stuff. Like, if somebody's landing on my page, why should I be liable for it? And besides, somebody else is putting it up there. Okay, we'll create some laws for that. To get fast forward now, 40 years later, it seems, almost, probably 30 years later, and we have an abuse of what the statute was intended to do.
Very much so.
And that is an overbroad protection for social media platforms, period. Now, I still believe in Section 230. I'm not saying we erase it. I think you do too. We're on the same page.
Very much so.
Right? But the idea is, this is way abused. I mean, these platforms need to be held responsible for policing their content to some degree. It's not our problem that they're giants, right? It's not our problem that there's billions of users. In fact, that's what they make revenue from. So the fact that you have this platform, the fact that you're such a juggernaut and you make billions of dollars selling information means you should be held accountable to some degree for content that's going through. And one exception I just want to point that
Sure.
you know, and for your listeners, how do we treat copyright issues? It's very interesting. So as you know, DMCA, the Digital Millennium Copyright Act, was also an amendment to existing copyright law, which was 30 years old at the time. But the DMCA essentially says, look, if you are a platform, if you are a publisher, and you are publishing content that is infringing, you can be held liable for it if you don't follow these takedown procedures. It's a 10-day process. You know, there's a respond.
Yep.
There's a bona fide good faith takedown where you presumably can take it down, right, within 10 days. And no harm to you as platform. Why don't we have something like that, right?
Bingo.
And it's like what we're telling people, what we're telling the American people is we value art and creativity more than people's lives themselves.
Well, that's exactly it. And it's interesting that you point that out because, you know, I watched all of the entire hearing yesterday for hours. And what was interesting to me between the ways in which Zuckerberg and Dorsey were answering questions is that a lot of the questions that Zuckerberg was being asked about tools that Facebook could be implementing. Is it implementing? Has it ever implemented them? He had no idea. At what point he didn't even know the name of a particular tool that one of the senators said, hey, you're using this tool. What does it do? Well, Senator, I'm not familiar with any tool by that name, but I'm sure we have tools that do things like that. My whole point is, yes, it makes sense for Mr. Zuckerberg to be there, but why not have subject matter experts from within the company who can answer those questions? In my opinion, these hearings really did very little in terms of adding value as to the direction that our law needs to take, other than both platforms, Twitter and Facebook, say, yes, we want to abide by Section 230, but we also understand that it needs to be modernized, but nobody wants to execute on that. Nobody wants to do the work to make that happen. And, you know, coming into probably one of the bigger defamation cases of this year is what's been going on with the Amber Heard and Johnny Depp lawsuit. And I know you and your firm have done a wonderful job keeping your followers and clients and the general public updated on that. Let's talk about that. What gave rise to this lawsuit? Why is this so back and forth? Why is it just drama?
Yeah, it's really interesting. So for those who are keeping up, basically there's two lawsuits. They are independent of one another. One is in the UK. That's the one that most recently people are yapping about because basically Johnny Depp's case as a matter of law was dismissed recently in the UK. So that case was Johnny Depp suing a publisher because in UK you don't have Section 230. So you can sue publishers without getting these obstructions. To nice. right, keeping publishers honest. So he sued them for basically their article wherein they called him a wife beater, basically, and said he abuses Amber Heard. He's physically violent towards her, and so he sued for defamation. And so naturally, you have to similar to our American system. You have the burden. Plaintiff has the burden of proof, so he has to prove the falsity of the statement. So there's a testimony. By him, by Amber Heard. There's evidence. People coming forward saying, this is why he's not an abuser. She's the aggressor. This is why he is an abuser. Here's the, so-called evidence. And so this was before a judge, on this particular motion. And the judge looked at it and said, I'm sorry, but I actually believe that there's sufficient evidence to conclude that a newspaper could conclude that he could be a wife beater. And I thought that was a gross miscarriage of justice. And I haven't seen all of the evidence. But speaking purely as a lawyer, which is what our job is, looking at the facts, there is audio of Amber Heard admitting to throwing pots and pans at Johnny Depp. And 3 months before this audio is 3 months before their divorce, in 2016, her chief complaint is not abuse. In fact, I don't think she ever claims that he was even the aggressor in any of those audio tapes. And yet you have after the divorce, you have all these allegations that, well, actually he was physically violent. But going back to what was, produced in the UK case, and I don't know all the evidence, I haven't seen everything, but there's some testimony to support this idea that there is not sufficient evidence for a newspaper to be claiming that he is a wife beater.
It's not their job.
Right. And so I was set back by it from a legal process standpoint. Sure. Again. And there's something else going on in the background, right? So let me pause for a second. There's a US case that's still pending, right? I think it's in LA County Court. I don't remember. But it's Johnny Depp suing Amber Heard directly for first party statements that she's made. And so that case is still going. But if you watch, I don't know if you've seen any of the court TV deposition videos. It's on YouTube. You can watch it.
Yeah, sure.
Amber Heard comes unhinged, and unhinged in a way that is kind of scary. And once again, the scintilla of evidence in her favor to show that actually Johnny Depp is an abuser, I don't see the weight of it compared to the weight of Johnny Depp's evidence. Winona Ryder testified. She was ex-fiance of Johnny Depp. She testified in UK and said this has never been the case. Many people came forward and said Johnny Depp has actually been complaining about Amber Heard being abusive, right? And it'll be interesting to see what happens in the US. You've probably seen video or pictures of Johnny Depp in the hospital with the lacerated finger. And who's denying that happened?
We have the COVID-19 pandemic has revealed a very disturbing, atmosphere or landscape for at least the US. And it's a systemic bias on many accounts, on grounds of race, equality, social justice, and the idea that a man cannot also be a victim of physical abuse, harm, sexual assault is problematic. Now, granted, it goes the same way. Not all men feel that they can come out and share their story, just as a lot of women don't feel safe to come out themselves. So I think that plays into it in this case, that there's this notion that, well, it's Johnny Depp, he's bigger, he's her, and who could ever abuse him, right? And I think those are arguments that should be taken into account. But what I've noticed is that regardless of what side you're on, I'm on, anybody is on, there's a potential for individuals like you and I to be defamed ourselves. Have you had any experience with that in your tenure or practice, where your job is to represent and defend? And yes, you have the choice of who you choose to engage that attorney-client relationship with, but is it common for you or somebody in your position to be defamed simply for doing your job or representing somebody?
Oh, 100%. 100%. My firm's been attacked. My partner's been attacked. I've been attacked. And it happened several times this year, but even in the past. To give you one example, we're in an environment where, again, especially now because of all the civil rights issues that are coming forward, where people believe you can get away with saying things on either side, right? And I'll give you an example. Hey, this person is a neo-Nazi, racist, anti-Black Lives Matter, anti-Muslim, KKK person. You say that enough times or once to a supplier, they're not doing business with you.
Nope.
That's a slippery slope. The opposite is also true, right? Somebody who's been a victim, who's been subject to race-based or gender-based or religious-based hate speech, the person who's perpetrating that deserves to be outed. But it's a fine line because there are repercussions, and you don't have a right. In the United States, most every state has a tortious interference on top of a defamation statute.
Sure.
You don't have a right to interfere with the private matters of an individual, especially a business owner. And so coming back to us, 100%, oh, this law firm, and you can believe somebody says to me, like, doesn't support minorities. I'm like, really? Have you looked at me? Have you gone on my website? Like,
unbelievable.
I'm on the board of a civil rights organization. Like, and just because they believe you can get traction, right? You say it enough times in your closed bubble, it's an echo chamber. That's all people hear.
And social media exacerbates that to bring it back. It's a toxic tunnel of information just being circulated.
100%. And so the backlash is real. I hope one of the things that comes out of this year is that people take everything they read and hear with a grain of salt. Look who's the speaker. Are they an expert? Are they somebody with, an agenda? Whether it's a case or whether it's social media. I hope that people do their diligence and simply don't buy into what they read and hear. I mean, it's unbelievable.
It's definitely concerning, and it's a shame that even today with our news and media that we can't trust any one particular source. And I've always been one to look at all of them, see what the narrative, how that narrative is being told, and then the ability for me to generate my own opinion, keeping in mind that there may be questions that I want to ask. And, you and I have that privilege of being, in the legal profession and having that kind of access to certain resources like, Pacer and these, these systems that a lot of people don't. But at the same time, it doesn't hurt to read, to Google, to ask questions yourself. And it's a problem. And I think there should be a standard of accountability when it comes to defamation, libel on social media. Is this objective harm, the threat of force, the threat to destroy somebody's livelihood. Those are the only criteria that really make sense. Otherwise, as you said earlier, you called me mean, or you said that, I don't like this, it's just a he said, she said. But when it starts to interfere with your everyday being, your reputation, which affects our profession, that's a problem. So.
It is. And I have a case right now where the judges just don't get it. I have a couple of cases like that. And the judge has already ruled it's defamation. We're waiting on a permanent injunction. And people are hesitating about, prior restraint, free speech. I'm like, the law has already established that this is not unconstitutional. You can grant this injunction. Why the hesitancy to hold people accountable for what they're saying when it has already been determined to be damaging?
Systemic bias, personal opinion, subjectivity that has no belonging in a courtroom. Now, can you keep it out? No, we're human. But at the same time, you can't have, and this is me kind of pushing the bounds a bit. I don't think it's fair to have a jury pool of people who have absolutely no idea how social media works. If we're talking about a defamation case, have a jury pool that is consisted of people that are in the industry. I don't know. Maybe I'm crossing lines here, but there's got to be a way to have the right people, or at least people that are able to think in those mindsets, right? There's judges that are on social media, right? They have their own pages. I don't know. So
it's 100% bias, like you said. It's the inability to look at facts, look at law, make a ruling. And of course, federal judges are political appointees in a large way, right? They're appointed for life terms.
Sure.
So it's really hard. And then of course, getting third-party platforms to obey, although they're not parties to the litigation, to comply with their own policies. When you have a court order that says this is false, this is defamation, this is tortiously interfering, here's a judgment, here's an order. Oh, well, we'll look at it.
Well, that's what it is these platforms are weighing court orders against their own privacy policy or terms of service, saying, well, it may be a violation in your court, all pun intended, but it's
Right.
not ours. It's not in ours.
That's right.
Oh, that's a problem. And to real quick, an interesting hypothetical. I've asked a few people, and I've gotten some hate, gotten some shade from it. Our election season, our sitting president, despite any political beliefs, is it ever possible? Could it be possible for a sitting official, a president, to be held liable for statements made against our country that could pose a threat to our very own constitution, our democracy, our national security? Is there a world where that could happen?
I think it's an interesting hypothetical. I've thought about this myself, especially when you make allegations of, well, the other side is engaged in fraud, or this state or this governor did X, Y, Z, like literally throwing away ballots.
Sure.
Things that there is no evidence for that I've seen personally, and especially when it's so early that it can't possibly be any evidence of something like that. I think it would be an interesting hypothetical that, yeah, sure. Obviously, there's immunity issues, qualified immunity issues, and public figure and all that. But put those things aside. Is there falsity? Is it provably false? To a scientific degree, it can almost be provably false, right? Some of these claims about voter fraud, and here in Arizona, we had people talking about Sharpies. Like Sharpies suddenly became, the #1 hated pen.
Things people come up with.
Yeah, right. And so, yeah, I mean, hypothetically, there could be an action for defamation or an injunction to say, you know what, you need to stop, because this is no different than yelling fire in a movie theater, which is an actual case, right? A decades-old case. This is no different. It's creating harm. There are ripple effects. It's not that you cause somebody monetary damages, but this is something that should be enjoined. You shouldn't be making these things because you're causing a ripple in the United States of America that is unwarranted and unfounded.
Very much so. It's an interesting question. And like I said, I don't know what would ever come of that, but the ability to think of that, people just need to be able to think for themselves and not get their opinions from news articles or any news network in particular. It's just people need to learn to think and do their own research.
That's it.
Raees, how can people find you? How can people contact you?
Yeah, well, you can visit our website. It's my initial, rmwarnerlaw.com. We blog a lot. There's some great free content there. You can also follow us on social media. Our handles across the board are pretty much the same. It's RM Warner Law. We're pretty active on Instagram as well. We try to do lives. And if anyone's watching and wants to do a live or a video recording like this, we're absolutely open and willing to do it.
Well, this has been wonderful. I know you and I will have many, many conversations to come, but I thank you for your time, and I thank you for talking. This is a tough area. So thank you for the work that you do. It's definitely not easy.
And thank you, Andrew, for all the hard work you're putting in, and especially in the harassment world, making people, driving awareness, particularly to the media. I've seen your Twitter battles and things like that. I think this is really important stuff. So we appreciate what you're doing.
Thank you. And look, there's a difference, and I appreciate that. There's a difference between bullying and then calling individuals out who violate ethics, who violate another person's ability to share their opinion. And people mistake calling those individuals out for bullying. So it's when I asked you earlier about, are you susceptible to defamation yourself with the work you do? And you said, absolutely. No different. So I appreciate that. I'm glad you recognize that. And I look forward to the work that we can do in the future together.
Excellent. Looking forward to the next one.
All righty. Thank you, everybody. And we'll see you next time on What's the Legal.
Thank you.